President of CIArb, Mrs. Anne Ryan Robertson, Chairman Rengen Johnson, Bahamas branch, distinguished members and associates of the Chartered Institute of Arbitrators, students, judges, lawyers, professionals from all walks of life, guests, good day and welcome to this webinar being hosted by the CIArb Bahamas branch. Our moderator for this evening is Mrs. Carla Card-Stubbs. Carla is multifaceted and multi-talented. She is an attorney at law, a tutor at the Eugene DePute Law School. She has been admitted to practice in Jamaica, BVI, and the Bahamas. And she's a fellow of the Institute of Chartered Arbitrators. We invite you to listen keenly, take copious notes, and enter your questions in the question and answer tab below. And feel free to use the chat to introduce yourselves and where you're zooming from this evening. We hope that you will find this session inspiring, informative, and it will motivate you to mentor others as we build a cadre of mediators and arbitrators worldwide. So without further ado, I hand over to Mrs. Carla Card-Stubbs.
Thank you, Donna. Good evening, all. Good evening, Madam President, colleagues, attendees, friends, all. I adopt the protocol that has already been established, and it is my absolute pleasure to serve as your moderator for this evening's webinar, well, evening or morning, depending on where you're joining us from, and welcome. The Chartered Institute of Arbitrators is the world's leading qualifications and professional body for dispute avoidance and dispute management. The Institute, CIArb, some of us say CIArb for short, is passionate about promoting our harmonious society and helping people and organizations avoid, manage, and resolve conflict through its global network of over 17,000 members. The Institute also provides education and training for arbitrators, mediators, and adjudicators. And tonight's event is in keeping with the mandate of education. In the Bahamas, we boast a pool of internationally recognized and accredited arbitrators and mediators, and you'll meet some tonight. They are active and well-equipped members of the Bahamas branch of the Chartered Institute. As such, the branch is well poised to provide professional expertise in this matter. And it is important to the professional development and evolution of the branch that events such as this are facilitated from time to time. This evening's webinar has been entitled CIArb and its Courses. And for this event, we're pleased to have none other than Ms. Anne Ryan Robertson, the Global President of the Chartered Institute, to present to us on that topic. There will be an opportunity to ask questions after her presentation. That distinguished members of the Bahamas branch. They will present on the progress made by the branch in developing a legislative framework and the opportunities that are available in the current environment. Each panelist will speak, and that will be followed by a period of question and answer. We expect this evening to be chock full of important and interesting information, and we look forward to the insights to be shared by our various presenters. And so we thank you for choosing to spend your time with us this evening. At this time, I will invite the chair of the Bahamas branch, Ms. Rengen Johnson, Fellow, to bring us a warm welcome and opening remarks.
Welcome, distinguished members of the Chartered Institute of Arbitrators, England, members of other branches of CIArb, the members of the Bahamas branch, students from EDLS, registered guests, ladies and gentlemen, good evening to all of you. It gives me great pleasure to welcome you as the present chair of the Bahamas branch to our second webinar for the term 2021-2022. The topic of our webinar today is CIArb and ADR courses. With increasing integration through online webinars and meetings of CIArb, we are becoming a formidable global family as we promote alternative dispute resolution under the umbrella of the distinguished CIArb, which was established in England on 1st March 1915 and was granted a royal charter by Queen Elizabeth II in 1979. We appreciate and thank you for your participation by attending today's event. To know more about CIArb, its ADR courses, and the Bahamas branch through the list of distinguished CIArb fellow panelists. I wish to also take this opportunity to congratulate and thank all the Bahamas branch members who have contributed to the creation and advertising of this webinar. I wish to also add that I'm a qualified barrister, attorney at law, and it gives me great pleasure to say that I was born in Istanbul, Turkey, because I see some Turkish people have joined us. Welcome, welcome to Turkish persons with CIArb, as well as everybody who has joined us this evening globally. And therefore, I wish to take this opportunity, as I said, to congratulate and thank you, everyone being here. On behalf of the Bahamas branch, I'm very proud to welcome and to introduce to you our special guest speaker, Ms. Anne Ryan Robertson, who is the Global President, Chartered Institute of Arbitrators, our global president. Our president has a very, very accomplished biography in respect to her education and professional life. She is a chartered and fellow arbitrator. Anne is an international partner in Locklord LLP's Houston office in USA and acts as an arbitrator and counsel in complex business disputes. She holds a Juris Doctor degree and a Master of Law in International Economic Law and is an adjunct professor at the University of Houston Law Center. Anne's name was added in Global Arbitration Reviews, whose legal arbitration since 2015. And in the Best Lawyers in America, International Arbitration / Governmental since 2014. She is a member of many arbitral institution panels, which includes International Center for Dispute Resolution, the Singapore International Arbitration Center, the Hong Kong International Arbitration Center and Asia International Arbitration Center, the Korean Commercial Arbitration Board, the International Institute for Conflict Prevention and Resolution, the British Virgin Islands International Arbitration Center, the Maldives International Arbitration Center, and the Court of Arbitration for Art, an author and frequent speaker on arbitration issues. Anne is a recipient of many awards and honors, the most recent being one, the United States Department of Trade selected her as one of the 10 arbitrators appointed by the United States to serve as a dispute settlement panelist, according to Chapter 31 of the United States-Mexico-Canada Agreement. Anne is a supporter of diversity in arbitration and is a founding member of Arbitral Women. I thank you, President Anne, for accepting my invitation to share your experience and vision of CIArb and ADR courses at this present event. Ladies and gentlemen, I present to you our esteemed guest speaker, Anne Ryan Robertson, the Global President of CIArb. Welcome.
Well, thank you very much. I adopt the protocol that has been stated by those speaking before me. And I thank you for that most gracious introduction. And I also thank you for this invitation to speak to the Bahamas branch. I'm very fortunate to have many friends from the Caribbean as a result of my having taught Chartered Institute courses in Jamaica and Trinidad and Tobago, the BVI, San Lucia, and the Caymans. Unfortunately, I've never had an opportunity to visit the Bahamas, and perhaps this omission will one day be rectified. But I am here today with you remotely and welcome the opportunity to speak to you. In my time with you today, I'm going to explore a number of different topics and not just the training programs that the Chartered Institute may offer. I'm first going to give you a brief history of the Institute because some of you may not be aware of its origins. Then I'd like to share with you some of the Chartered Institute's current initiatives and programs. And you'll see in that particular section that there is some discussion of some very exciting educational programs that are being launched. Then I'll talk, and it will end up being somewhat brief, about the training programs themselves. And finally, I was urged to speak on how one goes about developing a career in mediation and arbitration. I will tell you right now, I have no crystal ball, but I will be happy to share some thoughts that I do have regarding how you may be able to raise your profile. I want to turn first to history. As has already been mentioned, the Chartered Institute was established on March the 1st, 1915 by 5 men, 2 solicitors, an architect, an accountant, and a surveyor. And they banded together to form an organization with the aim of raising the status of arbitrator to the dignity of a distinct and recognized position as one of learned profession. The original objectives of the Chartered Institute stress the need to support and protect the character, status, and interest of the arbitral profession. And this was going to be achieved by testing through examination the qualifications of candidates for membership, by encouraging the practice of settling disputes by resolution, and by promoting the study of law and the practice of arbitration, and where necessary, supporting its reform. These men were true visionaries. In the early 1900s, there was hostility to arbitration from the judiciary in most countries. For example, in my own country, the United States, the Federal Arbitration Act was enacted in 1935 specifically to overcome the court's hostility to arbitration. Courts are required, with limited exceptions, to send all cases to arbitration where the parties had agreed to arbitrate and have no jurisdiction over the arbitration process itself. After World War II, the world saw a boom in international trade with the concomitant cross-border disputes, and that was the impetus for the 1958 New York Convention. But not all countries readily embraced it. In fact, the United States did not ratify until 1970, and surprisingly, the UK not until 1975. Now, 1972 saw the first overseas branch of the Chartered Institute being formed, and that was the East Asia branch. And as has been mentioned, in 1979, the Institute was granted its royal charter, and it has a public interest mandate to promote and facilitate worldwide the determination of disputes by arbitration and alternative means of private dispute resolution other than resolution by the court. As you can see, the mandate is much broader than arbitration and encompasses mediation, adjudication, and any other ADR technique that may be available. Today, the Chartered Institute has over 17,500 members in 149 countries. It also has over 50,000 followers on LinkedIn. The Institute works with governments and businesses the world over to help create an environment that is more conducive to arbitration and ADR. Those 17,500 members are divided into branches, and there are currently 41 branches. The largest is the East Asia branch with approximately 2,300 members. The smallest is Zimbabwe with 23 members. depending on the qualifications of the member, be it associate, member with a capital M, or fellow, you will be able to use postnominals after your name. And I'm sure each of you here is familiar with those postnominals. There is a fourth category, chartered arbitrator, which is held by approximately 500 fellows. Unlike the ICDR, the ICC, or the LCIA, or any other arbitral institution, the Chartered Institute does not administer arbitrations because, at its core, the Institute is a learned society promoting dispute resolution. That said, in limited circumstances, it does appoint arbitrators. To be appointed, the first criteria is to be on the president's panel, which is comprised of chartered arbitrators. A chartered arbitrator is defined as a fellow who has demonstrated to a peer interview panel an advanced knowledge and understanding of arbitration and its practical application. These postnominals that I have previously mentioned have worldwide recognition. They signal not only that you are knowledgeable regarding ADR techniques, but also that you maintain the highest ethics, because every member of the Chartered Institute is subject to its code of ethics. I'd like to share with you a personal story about the power of the postnominals. This was many years ago, and you will know that because I will tell you that I received a fax. And it came from a country that was known for sending faxes that were often scams. And I threw it in the trash. And then I got to thinking that on the letterhead, it had said that this person was a member, in fact, a fellow of the Chartered Institute of Arbitrators. And I knew that there was a code of ethics. So I pulled that letter out of the trash and I looked at it more closely, and he was looking for counsel to represent a client in court in Houston, Texas. And so I responded to his letter, and the result was that I was hired to be counsel for this particular company. And the case was one of great interest, generated very large fees, and created new law in the state of Texas. I'd also like to point out to you about the Code of Ethics and how very important it is to the Chartered Institute. The Institute takes this very seriously. Anyone, a layperson, a member within the organization, either may file a complaint against a member. If a complaint is filed, it is reviewed by the Professional Conduct Committee. And you'll see that the Conduct Committee is required to have at least one active or retired judge on the committee. Currently, there are actually 2 retired judges. In addition to other members that may be on the committee, there are lay members, and each complaint is evaluated. And if it's determined that in fact there may be a basis for further examination, the complaint is elevated. And in the course of that elevation, the member is afforded a full due process hearing. And if after the hearing it is determined that there has been a violation of the ethics, that there is the ability to strike that member off the rolls of the Chartered Institute. And for this, I'd like to give you 2 examples. A few years ago, there was an incident in which there was 2 members involved in a particular lawsuit on opposite sides. And one of the members was less than forthright regarding the status of a retainer. And a complaint was made, and ultimately it went through the entire hearing process. And that member was struck off the rolls. And importantly, that decision was posted on the Chartered Institute website, which they're entitled to do. And you might be interested to know that in one point, there was actually a president of the organization that was struck off the rolls because of a complaint. So that gives you an overview of the Chartered Institute, what we are, how long we have been around, and the organization to which I am very proud to be a member and to represent, and I hope you are as well. So now let's turn to the second topic. I want to share with you some initiatives and programs and what's actually been happening over about the last 6 to 7 months. First, as you are hopefully aware, we have a new Director General, Catherine Dixon, who joined us in June of 2020. She has brought a renewed and reinvigorated recognition of the importance of the branches, and hence the membership, as thought leaders in the field of ADR. And importantly, at least for my way of thinking, she is the first female Director General in the Institute's history. She offices at the Chartered Institute's headquarters at 12 Bloomsbury Square in London. There, a variety of directors report directly to her. Catherine is very conscious that at its center, the Institute is a member organization. To that end, she has instituted quarterly meetings with the branch chairs to bring them up to date on what has been occurring at the Institute and obtain branch chairs' comments and observations. And in recognition of the importance of the Americas to the Chartered Institute, we also have a new regional relationship manager, Brian J. Brannon, whose focus will be assisting the 7 branches of the Americas, which is North America, Canada, New York, the Bahamas, the Caribbean, Brazil, and Bermuda. Brian, who has joined us today for this webinar, will be residing in Miami, Florida, and promises to be an excellent resource for your branch. One of the first initiatives that Brian is undertaking is hoping to enhance communication and streamline all processes within the Chartered Institute with the hope of having a centralized calendar so that the various branches will not be in conflict with one another. Another initiative, and this one is extremely important to the global organization, is that we are attempting to enhance communication and streamline all processes within the Chartered Institute. To that end, there is a new director of IT and digital transformation, Mr. Jim O'Donnell. He is hard at work as we speak, examining ways to improve delivery of information and the overall digital transformation of the Chartered Institute. Another initiative that you may have been aware of is the Members Interest Panel initiative. The Institute invited members to join, and although it was hoped that the panel would draw the interest of 100 members, in fact, 1,100 members volunteered. This initiative will enable the Institute to engage members quickly on various topics in order to test and get valuable audience perspective on initiatives. The Chartered Institute has a calendar of issues that it wants to test, ranging from education and training product propositions to website ideas. And for the younger members out here, you'll be interested to know that the Chartered Institute is launching its mentoring program designed to facilitate mentoring relationships between some of our more senior and experienced members and those members looking for development support to progress in their own careers, particularly those from underrepresented groups. To deliver this program, the Chartered Institute has partnered with a company called MentorLoop, which offers a sophisticated online platform that allows mentees to pair with mentors and start a mentoring relationship based on their particular needs. This program is being run as a pilot at first, with a limit of 250 participants in total. It is open to associate and members, again, that's the large M, and is specifically intended for younger and less represented members. There are also a number of proposed structural changes to the Chartered Institute. And despite some of the proposed changes I'm going to be sharing with you, the branches will be continuing to report to the trustees. An organization of the Chartered Institute's size needs to be able to react swiftly and decisively. As a consequence, for some time now, the Board of Trustees has been looking at the governance of the Chartered Institute. The Board of Trustees' focus has been on continuing to comply with UK charity law, which governs the Institute, while strengthening and streamlining the governance structure In other words, to make the Institute more agile. As a consequence, a decision has been taken to increase the Board of Trustees from the current 12 to 15. Currently, the trustees are elected by region, and currently serving as the trustee from the Americas is David Huebner. I was fortunate to hold that position for 7 years. Under the new proposed program, the Board of Trustees will be increased to 15 and will consist of 10 trustees elected as always and 5 appointed. The 5 appointed will possess specific skills that will augment the elected trustees' expertise. And these trustees, in many instances, will be from outside the Institute. The Board of Trustees will make these appointments. The proposal will reduce the number of elected trustees from the UK to 3 from 5. The Board of Trustees will meet 4 times a year, and the Board of Management will fall away. Instead, there will be a series of subcommittees of the board which will support the Board of Trustees in delivering the Institute's strategic objectives that fall under the broad tranches of governance, operations, and advisory. While not an exhaustive list, governance will include audit and finance committees. Operation will include professional conduct and ethics, practice and standards, and appeals and advisory will include the membership committee and best practices committee. The Institute will seek to obtain applications for the members for all of its committee memberships, just as it has done in the past. Later in the year or early next, the proposed governance restructure will be circulated to the entire membership for reflection and comment. In addition, certain changes, such as the reduction of the number of UK trustees, will in fact require member approval. So now let's turn to some of the programs and education that the Institute has sponsored. First is the Young Members Group presented the Chartered Institute Young Members World Tour, Arbitration and Mediation as a Global Force for Good. This world tour, which of course was done via Zoom, traveled to 17 distinct regions throughout the world and highlighted the unique importance and efficiency ADR plays in allowing the world's economy to remain operative during times of great economic uncertainty, such as this pandemic. In total, the world tour attracted 1,477 attendees from 107 countries or territories. The world tour included 140 panelists, 70 of whom were female, thus achieving gender parity. 66 of the Young Members World Tour panelists were members of the Chartered Institute and represented 60 countries or territories. I must say that this program received great acclaim. You're no doubt aware of the case of Halliburton versus Chubb, which was decided by the Court of England and sets forth certain disclosure obligations that any arbitrator should address. The Chartered Institute sponsored a seminar on Halliburton and Chubb, and this particular webinar, well, there were 800 people attending. The lifeblood of the Chartered Institute are students. And in that respect, they hosted an International Student Open Day designed to introduce university level students to the Institute. In connection with the Student Open Day, the Institute launched the innovative ADR Student Experience Program, a virtual work experience designed to assist students in deciding if a career in ADR is right for them. We have already had a number of graduates from the program, and the feedback has been positive. Many of you may have attended the fireside chats held with the ICC Corp President, Claudia Solomon. Claudia and I discussed a variety of issues, and the ICC and the Chartered Institute are looking for means to collaborate in the future. If you missed our first two fireside chats, it's my understanding that there will be another in the Americas time zone. So look for information on that. The Chartered Institute, along with the London firm of Fox Williams, sponsored a pre-moot. And as it always has done, Chartered Institute was a sponsor of the BizMoot and had a virtual booth. International Women's Day featured a geographically diverse group of female Chartered Institute members who shared thought-provoking and inspiring comments that emphasized the continuing need for greater gender and geographical diversity in the ADR field. You may not be aware that the Chartered Institute is also an observer at the UNCITRAL Working Group 2, which is on expedited arbitration, and Working Group 3, which is focusing on investment arbitration. At Working Group 2, we intervened in the deliberations to draw attention to the Institute's cost-controlled expedited arbitration rules. And I might add that our interventions were very well received. One of the flagship educational courses that the Chartered Institute offers is its diploma course in international commercial arbitration. It was delivered virtually for the first time to 34 candidates in September of 2020. Given its great success, a further virtual international commercial arbitration diploma was delivered to 25 candidates from 18 jurisdictions in March of 2021. And there will be another diploma course this fall. In addition, a new diploma in international maritime arbitration, modeled on the International Commercial Arbitration Diploma, was launched virtually in September 2021. It had 16 candidates. And the Education Department of the Chartered Institute is continuing to scope out other thematic diplomas that it might offer. The Institute recently hosted the 11th Roebuck Lecture on the 10th of June, 2020. It was delivered by the Honorable Lady Justice Joyce Alcott, who is a former judge of Kenya. She had her lecture on the impact of Singapore Mediation Convention, both on mediation and arbitration. Following the presentation, Honorable Lady Justice Alcott and I entered into a lively question and answer session regarding the convention and its impact on arbitration and mediation. And we at least concluded that although it's in its infancy, the convention has the potential to strengthen the use of mediation in cross-border disputes. We also compared the mediation practices of our home countries to explore if there is a universal mediation standard. And in that, we both agreed there is not. Looking now at some of the other educational issues and programs that are being provided, there is a new online introduction to mediation leading to associate membership, which was launched in January 2021 on the back of the success of the online introduction to ADR. And the Education Department of the Institute is looking at professional progression and other membership course opportunities, such as perhaps expanding accelerated route to membership and accelerated route to fellowship programs. Delivery of education is being revisited with a view to make it easier for branches to deliver education within time periods that are convenient for the branches. And the department is working on a new automated assessment platform to allow branches to deliver courses flexibly. The Education Department is working on a new education and training models that will allow branches, subject to moderation, to develop and deliver their own training courses leading to membership. One of the current priorities this year is producing courses for fellows. New professional development courses currently being designed include practice and procedure of claim preparation, the power of presence in arbitration, and digitizing case management. So now let's turn to training itself. You in the Caribbean have a regional pathways leader, and that is Shan Greer of San Lucia. Now, each region of the Chartered Institute delivers courses, and those courses are selected in line with the perceived needs of the region. That means that sometimes courses are offered in one region that may not be offered in another. There is the pathway courses that are designed to take you through the entire process. You may be familiar with these. They're often called modules 1, 2, and 3. And depending on which modules you have completed will determine what your level of membership in the Chartered Institute will be. There are also accelerated courses for the more knowledgeable. We have an accelerated route to member course and an accelerated route to fellow. Each course that is offered, whether it's through the pathway courses or accelerated, leads to a qualification within the Institute, whether it be an associate, member, or fellow. If you're not following the Chartered Institute on LinkedIn, I urge you to do so. Not only will you learn of programs being offered by other branches, but also of online courses that are being offered, sometimes at a discount. Finally, I want to move to a point that I was asked to speak on, which is how to build a career in arbitration and mediation. Well, first, you need a general environment where arbitration and mediation can flourish. That means if the judiciary is hostile to ADR, the judiciary needs to be educated on the resounding benefits of ADR. If your arbitration laws are outdated or you don't have a mediation statute, well, the Chartered Institute, at the request of governments, can be involved in that process. Second, you need to educate the transactional lawyers. If they're not putting arbitration clauses in the contracts, there will be few, if any, arbitrations. You also need to educate students. The Chartered Institute has a student membership which is absolutely free. Currently, there are over 9,250 students who have taken advantage of the free membership. This 9,250 is in addition to the over 17,500 members. The students receive the various publications and are eligible for certain courses at a discount. There is also a program where universities can have their courses approved by the Chartered Institute, which will lead to the students being eligible for full membership in the Chartered Institute. Third, and the one you're probably most interested in on a personal level, is you need to develop your profile. And this takes time and energy. And you do that by taking training, by writing, by networking, and by attending conferences. My suggestion is that each year you set goals for yourself, such as I will publish one article and meet that goal. I chose article because writing is especially important in the international area because so many members of the International Arbitration community are academics. So many conferences today are remote and often free, but nevertheless offer networking opportunities over Zoom. In fact, that is how I met Tanya Goddard from the Barbados. I do not recall the conference, but we were in a Zoom networking group following the speeches of the day. Afterwards, we reached out to one another and are now in regular contact. Many of the branches have established young members group to engage the 40-year-olds and under in Chartered Institute activities. The World Tour is but one example. This branch, the Bahamas branch, might consider establishing a young members group. And of course, one should volunteer within the Chartered Institute. There are probably opportunities within the branch itself. I actually became the chair of the North American branch through serendipity and hard work. The then chair had been appointed judge and had to resign. The other members of the executive committee elected me to replace him. It was not a position I sought, but one that I gained because I had been willing to undertake mundane tasks no one else was willing to do. I might add, I was the first female chair of the North America branch. When the term was over, I ran for trustee and with support of the members of the Americas was successful. So that has been my Chartered Institute journey. Also, don't forget that from time to time, London will seek applications for the various global committees. Some may require certain expertise. Others may simply want to have member input, but all will create opportunities to raise your profile. It takes time, it takes personal courage, and it takes commitment to develop an international arbitration practice or mediation. Sometimes it takes thinking outside of the box. One of the things I did was to volunteer to coach the University of Houston's Viz Moot team. This is an arduous 9-month process, but at the competition, I got to meet other coaches and arbitrators from across the globe. Of course, to have a team takes money, but in the early years, I was successful in having businesses underwrite the teams. I knocked on doors and pled the student's case. In some instances, teams actually pay their own way, raising the money in any number of ways. They stay in hostels or apartments with 3 to 4 to a bedroom. For the past 2 years, the moot has been virtual, meaning there are no travel costs, which resulted in even more teams participating. Of course, as a coach, you will not be able to easily meet the other coaches and arbitrators in a virtual setting, but it will be rapidly known within your region that you are a coach, and you may reflect it on your resume, which will have global recognition. In the end, each of you will have to find your own way, considering your own dreams and aspirations, and hopefully lending support to one another. I certainly did not build my profile on my efforts alone. I have been extremely fortunate to have others support me along the way. And finally, please allow me to share that in 2022, sometime in the fall, the actual dates have not been confirmed, the Chartered Institute will host a worldwide conference in Singapore open to members and non-members. It is our hope that this conference will be in person, and I look forward to meeting many of you there. I thank you again for this opportunity to address you, and I wish each of you continued personal success. Thank you.
Thank you, President, and a lot of information in there. Thank you for sharing your journey with us on your own course and your own steps on your way to presidency. You shared the exciting initiatives being undertaken by the Institute, such as the centralized calendar, the streamlining of all processes, the membership panel. And I will say you even introduced live a resource to us in the person of the regional director, is it? Relationship manager, and he's online. Thank you so much for your input. And at this time, I want to thank you for agreeing to stay behind to answer questions, 15 minutes of questions. And I would like to remind our attendees that you can put your question in the Q&A box. We do have questions that were sent in advance, and we will defer to those. But please, if you do have questions, please put them. If you look at your screen, it should be center-ish, bottom right. You see Q&A. Please put your questions there. And so we will go to the first. Well, there were two questions there. I see it's been answered, but I'll just put it to the president in case she wants to share something else on it. The question was, does the young member group, the YMG, include, I imagine, young attendants who are not students? And I know you spoke a little bit to it in your presentation, but would you like to take that question?
Yes, I'll be happy to. The young members group is for actual members, those that are associate or members or fellows and under 40 years of age. The student membership is separate from the young members group. And if you're a student member, you age out of that, not by age, but by graduation. So once you have graduated from a university, if you want to be a member of the Chartered Institute, then you will need to show the qualifications necessary to then become a member.
Thank you. And the questions are rolling in. We have a question, Nicolette Gardiner. Is there a current course to move to membership status?
There are a number of member courses available around the world. Now, whether one is going to be offered in the Caribbean region or by the Bahamas branch, I don't know the answer to that. But yes, you have an associate's course and you do have a member's course. And that is the way you progress. If I might share with you how I progressed, there wasn't an associate's course. I was pretty old by the time I found out about the Chartered Institute and took my first course. And I actually would qualify for the members course initially because I had practiced long enough. And if you look at the website, you are going to see that it's going to tell you how many years you need to practice to be eligible for each level of membership. And I met that. So I took the membership course. And it was a little bit different then than it is now. And like everyone else who takes any Chartered Institute course, I kind of fretted over a lot of it because it is very intellectually challenging. And then the next year, I took the Fellows course, which, as everyone knows and everyone dreads, part of the Fellows course is you have to write an enforceable award. Fortunately, now you get to do that on the computer. I had to handwrite it. So there have been some instances in which there have been improvements in how things are done.
Thank you. And another question, will the Chartered Institute of Arbitrators be continuing to provide online trainings in the new year as well?
I think that I can tell you without a doubt that online training is here to stay. And there's a number of reasons for that. One is it can be delivered more economically. The other reason is you can reach more people. For instance, I taught a course in Brazil a little, 4 or 5 months ago, and we had people from all over the world that were participating. Now, some of them were having to participate in the middle of the night, but it was an opportunity for them to take the course that they might not have been able to take otherwise. So I do not see us going back to solely in person. Now, if a branch wants to do one in person, and I can give you an example, the North America branch is actually going to conduct in November an in-person accelerated route to fellows course. So it will be a branch decision in some respects.
Thank you. And I see no new question in the Q&A. So I'm going to go to the questions that were submitted in advance. And while we are on this topic, one of the questions submitted was in relation to building a career in ADR, in arbitration and in mediation. What would you call experience for domestic and international ADR? I know you gave us some nuggets on building, building one's career, but the question is, what is considered experience for domestic and international ADR?
Well, I think most people start out in the domestic arena because it's a little easier in the domestic arena. You're working within your region. So what is experience? Well, sometimes experience is hard to get, especially if you're young. People think you have to have gray hair to be a good arbitrator. So how do you get that experience? One way you can get that experience is to look around and see if there is any voluntary basis where you can volunteer to do arbitrate or mediate a local dispute, maybe neighborhood disputes. Some of my partners actually got their start on tax disputes. And if you'll look, you'll find that sometimes there are these local boards where you can go and ask to be on the panel and handle it in that way. The other thing to do is to be certain, if in fact you are a lawyer, to be the absolute best lawyer you can be, so that everyone knows that you are smart and that you understand the law. Now, I say if you are a lawyer, because interestingly enough, the Chartered Institute has many, many, many members who are not lawyers. We have members who are quantity surveyors. We have members who are accountants. Many of the mediators are not lawyers. So be the best you can be in your chosen profession as you try to then launch into either arbitration or mediation. The other thing to do is to take as much training as possible. And I'm not suggesting just Chartered Institute training. Go to programs, go to other training, anything that anybody's offering, especially if it's free. And that's one of the great things, you know, we have this pandemic has been a dark cloud over everything, but it has had a silver lining. And that is all of these things that are available online. And I urged you in my speech to sign up for LinkedIn, to follow the Chartered Institute, because you'll be amazed at the various things that are being offered across the globe. And LinkedIn, not only just through Chartered Institute, but just LinkedIn in general will give you ideas about all sorts of things that you can listen to and learn from.
Thank you, President. And I did make that note about LinkedIn and the fact that we could get discounts for online courses if we followed LinkedIn. And while we are on that, you did indicate in your presentation that there will be space for branches to develop and deliver courses that are appropriate, subject to moderation. And one of the questions that we received was, what is considered appropriate academic or professional or appropriate professional experience to be approved by faculty? I imagine it means as a faculty member to be a tutor, assessor, or examiner for one of these courses.
Well, that particular standard sometimes changes over the years. So I don't know where we are in this process at the moment. At a minimum, you are a fellow. I'm not aware of any member that has ever been qualified to be a tutor. And then typically what is required is recommendations from others that have observed you. Typically what is also required is that you shadow someone who has been approved, so that that person can watch you and determine if in fact it's appropriate for you to be a tutor. Then the applications are made, and at that point it's in the hands of the institute. Someone who can be a resource for you on this in your area would be Shan Greer in St. Lucia, as to just exactly what are the requirements at this point. I will tell you that the last course that I did in Brazil, I did have people that were shadowing me, and I did in fact give comments regarding them and their abilities to be a tutor.
Thank you for that. And there's actually a part 2 question. So if you don't mind, I'll just pose this now. Which department is available to communicate in person with CIArb members about applications for faculty approvals?
I am going to punt this one to Brian, and I would suggest that you first contact Brian, because he is going to be your liaison to London. And he in turn can give you instructions and direction or assistance relating to London. Sorry,
Thanks.
Brian.
Welcome, Brian. And we do see that email address, and I know that we're on it. Thank you, Brian. There are two more questions in the Q&A box. The first is there a standardized fee structure, or is it optional or at the discretion of the arbitrator? I
What
imagine
fee structure are we talking about?
I imagine it's for a hearing. Is there a standardized fee structure, or is it optional or at the discretion of the arbitrator? I
Okay.
imagine.
Okay, I wanted to make certain we weren't talking about courses here. Now we're talking about sitting as an arbitrator. It's going to, it's like many things in arbitration, it's going to depend. For example, if you're under an ICC arbitration, the ICC determines how much the arbitrator is going to make based on the amount in controversy. If you're in a AAA or ICDR arbitration, you have a resume on file and you have set your hourly rate and you will be paid your hourly rate. If you're doing an LCIA arbitration or a DIFC LCIA arbitration, they have a cap on how much you can charge per hour. If you're in Hong Kong, if you're at the Hong Kong International Arbitration Center, the parties get to choose whether they want to go with the ICC type model of how much is in dispute, or whether if they want to pay an hourly rate. So it depends. Now, your hourly rate, if in fact you're using an hourly rate, that is up to the discretion of the arbitrator.
Thank you. And we will take one last question in this session. And the question is from Pleasant Bridgewater. Can members practice outside their jurisdictions? Can members practice outside their jurisdictions?
I'm assuming that question is, can you be an arbitrator outside your jurisdiction? Yes, the answer is that most jurisdictions accept the premise that arbitration is outside the court system. And because it is outside the court system, you do not have to be admitted as a lawyer in that particular jurisdiction in order to be an arbitrator for an arbitration that is being held in that jurisdiction. Now, that being said, that is the general rule, but there have been some exceptions to it, including California for a time, but they have now changed that. So you do have to be certain what the rules are of that particular country. But for instance, I have sat in arbitrations, in Dubai, in the United States. I've appeared as an advocate in Switzerland. I've appeared as an advocate in London. So either sitting as an arbitrator or as an advocate, it is viewed as being outside the legal system and doesn't have the requirement that you be accredited in that particular country. China is an exception as well. China has some exceptions on what you can and cannot do as an advocate. So you just have to be familiar with whatever region you're looking to.
Thank you so much, President Anne. And at this point, I'm going to invite Ms. Yolande Rule, a member of the Bahamas branch, to bring the vote of thanks.
Thank you, Madam Moderator. Malcolm X once said, "Education is the passport to the future. For tomorrow belongs to those who prepare for it today." On behalf of the Bahamas branch, I would like to express our thanks to you, President Anne Robinson, for consenting to be our featured speaker for today. It is important to know your history so that you appreciate all the work and accomplishments that have taken place before you. Thank you so much for sharing with us the rich history of CIArb. And it is one that we are extremely proud of, and will do our very best to continue to build on all that was done before us. Over 17,500 members speaks volumes for this organization. We thank you for sharing. On our current initiatives and programs, we welcome the new initiatives within the region and are excited about the prospect of becoming more involved in the work of CIArb and in its new structure. About our training programs that you told us about, 700 attendees, over 700 countries. What an accomplishment. It was great to learn about our diploma course, and it's great to know that another diploma course is upcoming. Indeed, I am sure that I speak for all participants when I say that we look forward to the upcoming ADR courses that will allow us to continue our education in this virtual environment. The news about branches being able to deliver its own training courses is always welcomed. I assure you, the information on training was well received. And now, how about the question of how does one go about developing a career in mediation and arbitration? You mentioned so many wonderful ideas. The need for a general environment where ADR can flourish, the need to educate the judiciary, the need to educate the transactional lawyer, and the need for arbitrational clauses to be included in a contract. Importantly, the need to develop your profile. This is so important. I agree with you. Thank you for encouraging us to set goals for ourselves, to network, to write articles, to consider establishing a young members group. Indeed, young members are the future of the branch. The opportunity to participate in a global committee where the opportunity arises is one that we would certainly be willing to take part in. And the charge to us to become a volunteer, to be a coach, is such a wonderful idea, especially in an age when volunteerism is said to be down. I too am sure that many of my colleagues, or most of all of our participants in the webinar today, will love to meet you in Singapore in 2022 during the Worldwide Conference. We hope to see you there as well. Thank you for your words of insightful information and wisdom, and we will hold fast to the nuggets that you have given us today. Kofi Annan once said, knowledge is power, information is liberating, and education is the premise of progress in every society, in every family. And so we thank you today for giving us the information, and we wholeheartedly absorb it, and we thank you once again.
It's been my pleasure indeed. Thank you.
Thank you, President, and thank you, Yolande. And at this point, we're going to transition into our panel discussion. And I should let attendees know that there will be a further question and answer session at the end of the panel discussion. So if you had questions that you weren't able to articulate or have not been answered, we will field them at the end of the panel discussion. And we have 6 members of the Bahamas branch who will take part in the panel discussion. I urge you to go to our website or go to the international website, CIArb.org, to see the bios of these distinguished members of the Bahamas branch. And you will meet them there if you don't already know them. And I will tell you very, very briefly about them, but the 6 persons who will speak to you tonight will speak to you about various opportunities and happenings with the Bahamas branch. And the first to address us is the chair of the Bahamas branch, Miss Rangan Johnson. She is, as you'd heard in her introduction of the president, a barrister and an attorney at law, and a fellow. She has designation fellow, and the current chair of the Bahamas branch. She will speak to us about the vision of CIArb, the Bahamas branch. Please, Miss Chair Rangan Johnson. Madam Chair.
Yes, thank you so much. I just have muted myself. Thank you very much for your introduction. And I would like to share my vision for the Bahamas branch. As the chair of the Bahamas branch, my vision is to promote ADR proceedings as an alternative to judicial litigation, to maintain the Bahamas branch standards and its values in compliance with the Chartered Institute of Arbitrators, governance structure, bylaws, and ethics, to increase diversified membership through recruitment campaigns to attract young students, members of professional backgrounds, including and not limited to commercial, judicial, industry, entrepreneurs, civil servants, etc. To promote, to create an international corporate arbitration center with the support of the stakeholders to identify and train qualified administrative officers to provide services to the parties with specific needs and expectations. By use of memorandum of understanding, connect with other centers to create links and to promote ADR. To select hybrid and virtual conferences, seminars, workshops, meetings, etc., which will result in global communication and an increase in membership. To complete and expand ADR legislation to support an ADR center by attracting to the Bahamas ADR disputes by adopting international popular procedural rules with clarity, flexibility, and efficiency. The branch has adopted virtual and ADR courses, which will decrease the costs and increase the attendance due to convenience, as it is the case today. To continue with further education and training in ADR courses to increase the experience and qualifications of the branch members. Outreach and work with external organizations to promote a broader knowledge of ADR through a range of courses, events, and publications by organizing local events, to network and participate in international conferences and CIArb branches to share knowledge, training, opportunities through CIArb's training diaries. That's the global calendar, so we can keep up with each other's programs and support each other. With the support of the stakeholders, including Grand Bahama Island, commercial and industrial population, the resident CIArb members, fellows, and others to apply to CIArb to create a chapter in Freeport, Grand Bahama Island. The chapter will offer ADR services in respect to disputes, especially relating to maritime industries, pharmaceutical, oil and gas, industry and environment, and so forth. To strengthen the structure of the branch by successive training with CIArb, initiating development actions to support the branch's structure and diversity, to promote goodwill and top service to address the inquiries and resolve the problems of the branch members by adopting quick solutions through the branch and CIArb England. Locally and globally, advocate equality, responsibility, transparency, and professional protocols for communication by complying with the purpose, values, and strategies of CIArb. To endorse efficiency of the branch by complying with CIArb's digital structure and training, so well explained by our president, Anne. I am so glad that we're going to another era. To be an inclusive branch by including our membership to guide the branch in selecting the courses and training through direct communication and surveys. Inviting the young students and members to be a part of the branch's ADR legislative committees. Organizing meetings by including members and their associates in events organized by the branch. To develop and encourage mentorship as part of the training by CIArb and its branches. to maintain the public image and reputation of the branch by creating and maintaining the branch ethics committee. The branch's success with ADR and the center shall have a positive impact financially and commercially. It will support and definitely benefit the judicial system, the government departments, and finally, our blessed nation. I do hope you have enjoyed my presentation, ladies and gentlemen, and my guest speaker, who I've been very impressed with since I met her in 2014 through an email communication. My vision for the branch, I hope that will be supported by all members and those persons to become members. I thank you all, and especially our special guest speaker and all the panelists and all the attendees. And I hope you will enjoy the rest of the presentation. God bless you all. And I wish you a safe journey if you are going home. God's blessings. Thank you.
Thank you, Madam Chair. You heard the vision for the branch, and I should indicate that this is the first ever international webinar for the Bahamas branch. We are evolving. Thank you, Madam Chair. The next panelist that you will hear from is Mrs. Cherise Cox-Nottage. Cherise is an attorney at law and the head of the Legal Compliance and Operational Risk Departments for UBS Trustees Bahamas Limited. She's a past chair and she holds the designation fellow. She will address us on applications for arbitration and ADR. Please, our next panelist, Cherise. Thank you, Cherise.
Well, thank you very much, Carla. And I must say, following those two incredibly accomplished women in our chair, and of course our president, Mrs. Robinson, is quite a task. I hope I can go some way to living up to their presentations. I would also like to mention, before I actually kick off, I propose to go through what some may see as perhaps some rudimentary aspects of ADR, but I'm bearing in mind that there are others on this webinar, as you say, our first initial international webinar, who may not be up to the standard of the other mentions on the call. So thank you all very much, and I'll begin. My presentation is on applications for ADR. Alternative dispute resolution is any method of resolving disputes without litigation. That is, resolutions that are not imposed by the courts of a jurisdiction. Arbitration and mediation are considered as the two primary forms of ADR. Why are they becoming so popular? Well, as queues to access the courts get longer, the rising costs of litigation and delays altogether continue to pose challenges, and states have instituted ADR programs to address some of these challenges. Mediators are trained in negotiation and bring opposing parties together to attempt to work out a settlement. The mediator does not decide the dispute, but helps the parties to communicate so that the parties can attempt to settle the dispute themselves. Mediation leaves control of the outcome with the parties. Mediation is generally not binding. However, the recent advent of the Singapore Convention has conceptually expanded the traditional characteristic of mediated settlements as being until recently unenforceable. Cases for which mediation may be appropriate are when parties have a relationship which they want to preserve, for example, with family members, neighbors, or business partners. Mediation helps the parties to communicate with each other in an effective and non-destructive manner. Mediation can be applied to a wide range of case types, ranging from breaches of law by juveniles to, for example, the US and Canadian federal government's negotiations with First Nations and Native American Indian tribes. In some instances, mediation has also become a significant method of resolving disputes between investors and stockbrokers. Cases for which mediation may not be appropriate include instances where one of the parties is unwilling to cooperate or compromise. Mediation may also not be particularly effective if one of the parties has a significant power advantage over the other. Accordingly, it may not be a good selection if the parties have a history of abuse or of victimization. Arbitration. Arbitration is seen as more formal than mediation and is said to more resemble a simplified version of a trial involving truncated discovery and evidence rules. For example, hearsay evidence can be admissible in arbitration. Prior to a dispute occurring, parties usually enter into a binding arbitration agreement or other form of agreement with an arbitration clause, which allows the parties to set out key terms for the arbitration process. For example, numbers of arbitrators, the forum for the arbitration, the rules for the arbitration, fees, etc. Arbitrations may be either binding or non-binding in nature. Arbitrations can also be ad hoc or with administrative support coming from one of the institutional providers. Arbitrators do not have to be lawyers. Parties can select arbitrators from other fields which they consider to be more suitable for the resolution of a dispute. For example, parties can choose an arbitrator with an engineering background to arbitrate a construction dispute. The panel or a single arbitrator deliberates and issues a written award, which does not form part of the public record. Arbitration has long been used in labor construction and securities regulation and is now gaining popularity in other business disputes. In 1958, the New York Convention was drafted to aid in the enforcement in the local domestic courts of arbitration awards granted in foreign countries. Cases for which arbitration may be appropriate are where the parties want another person or body to decide the outcome of their dispute, but would like to avoid the formality, time, and expense of a full trial. Arbitration may be appropriate for complex matters where the parties want a decision maker who has training or experience in the subject matter of the dispute. Cases for which arbitration may not be appropriate are those where parties want to retain complete control over how their dispute is resolved. Arbitration, particularly binding arbitration, may not be appropriate. In binding arbitration, the parties cannot appeal the arbitrator's award. The good news is that a number of companies are using ADR effectively and are benefiting from lower costs, quicker dispute resolutions, and outcomes that preserve and sometimes even improve relationships. In a case involving one of the oil company giants in the 90s, an ADR-based mediation of a dispute cost $25,000. It would not be unusual for litigation costs even then to have been in the region of 2.5 million over a period of 3 to 5 years for the very same dispute. Winning at all costs is not good business. Success needs to be evaluated not only in terms of lawsuits won, but also on disputes avoided and relationships preserved. As a final comment regarding the applicability of ADR and the need for ADR to expand diversity within its ranks of practitioners, I'm certain that many of you would have heard about the recent case involving the suspension of US star athlete Sha'Carri Richardson by USADA, the US Anti-Doping Agency, which is a branch of WADA, the World Anti-Doping Agency, both of which are arbitration panels which oversee substance testings of athletes. Also, you may have heard of the recent fines against the Norwegian women's beach handball team by the ECA for the team's crime of crimes, sin of sins, failure to wear bikini bottoms during a recent match and to have instead worn shorts. Oh, the shock and horror. The ECA, the European Court of Arbitration, is a court of arbitration for the sport of handball. Both decisions point to the need and value of diversity of voices and experiences in ADR processes. I hope that many more of you will choose to lend your voices and experiences. Thank you.
Thank you for Cherise. Interesting. And that's real current events, that dispute going on. Thank you so much for that.
Welcome.
And I do want to remind the attendees that if you have questions, please put them in the Q&A box. And we will get to them at the end of this very, very interesting panel presentation, and which will transition into a discussion. Our next panelist coming to speak to us on mentorship opportunities in CIArb is retired Justice of the Supreme Court of the Commonwealth of the Bahamas, Justice Ruby Nottage, who is an associate professor of the Faculty of Law, University of the Bahamas. She too is a fellow of the Chartered Institute of Arbitrators. Justice Nottage will speak to us on mentorship opportunities.
Thank you so much, Mrs. Carla Card-Stubbs. Good day and good evening to all participants, wherever you are at this CIArb event. I adopt the protocol established earlier, and with due reverence and respect to our President, Ann Robertson, and our Chairman, Ms. Rangan Johnson, I have been asked to speak on mentorship opportunities in CIArb or CIArb. And there can be no topic of more interest to me or more dear to my heart than mentorship within this learned society known as the Chartered Institute of Arbitrators. Mentorship is widely defined as literally providing CIArb members, both young and not so young, who may be interested in arbitration and ADR, with the opportunity to learn from the experience of more senior members of the arbitration community. It's a harsh reality, however, that practice in the field of arbitration is not an easy stroll down Main Street. The practice of arbitration, and particularly international commercial arbitration, in which I have a particular interest, that practice is better described as a battlefield of equally trained and adept ninja warriors, and you'd better be prepared. Whether one sits as an arbitrator or counsel for an applicant, arbitration is not the arena for the faint-hearted. In order to transit this terrain, there is a real need for a mentor. In a CIArb mentorship program, such as that already on the drawing board in some CIArb branches, for example, I understand that CIArb Egypt has a protocol that they have begun, and even closer, our CIArb Caribbean branch has established a young members group led by Jodie Peterson, with the encouragement of Shan Greer, and that's taken root. So mentorship is on the rise, and watch this space. In such a program, the branch undertakes the formation of mentoring groups, which are comprised of 1 to 4 mentees or new members who are assigned a mentor, a senior arbitration expert, ADR expert, or a practitioner in one of the processes. At regularly scheduled intervals, the mentor is available to provide the mentees with career guidance and arbitration practical knowledge, or ADR practical knowledge. Branch mentors are able to guide many a fluttering heart into the right paths. There's also the interaction with fellow mentees who are being mentored, as that is also an invaluable outcome of the CIArb mentorship program within our institution. So what are some of the steps? And I'd like to share with you from my own experience, personally, the preparation and the strategies that go into the mentorship of a fellow in arbitration, let's say. First of all, you must know your battle gear, and your mentor is going to tell you that you have to be equipped for the battle that's going to be ahead of you. CIArb courses have already been mentioned by President Robertson. Those are good, they're readily available, and you should take full advantage of them. but primarily the main message is educate yourself. Present the best bio or CV that you can, and become a spokesperson for the specialty that you are wishing to present your expertise on. I, for example, undertook the Director of Education post in our branch, and I found that very helpful because it helped me to understand the pathways of the CIArb educational offerings. I followed international commercial arbitration, dispute resolution courses, and I didn't stop there, you know. I have one of these sayings that continuing education is a must. And would you know it, even at my age, I heard about gray hairs, but I don't show it. Even at my age, I am going to attend the upcoming flagship course in international commercial arbitration beginning 3rd September. That is a must for anyone who wants to stay current in this topic. All right, educate yourself. Choose a specialty that will raise your profile above that of others. I chose international commercial law and arbitration. Maritime issues are important. Foreign investment, dispute settlement is important. At the time that I became interested in arbitration, I was a member of the Anglican Episcopal Church as its chancellor. So canon law became my strong field. And as a result of that, I'd like to say that I, having learned the aspects of ADR, was chosen to be a member of one of the actual teams that the Archbishop of Canterbury chose in order to settle some of their very strongly held disputes. So it does help to be specialist. Secondly, I'd say arm yourself with some necessary emotional intelligent qualities. Humor, you've got to be able to laugh at yourself, you know. You have to have courage to speak as you see it and speak the truth, even to those who are in power. You have to have tenacity about your points of view. You have to have perseverance and what I call stick-to-itiveness. That's a word I've made up. It means that you must stick with that battle until it is over. Finally, thirdly, mentorship opportunities in and through the CIArb branches will allow you to explore and design your strategies for success. How do you become an arbitrator? Where are the arbitration opportunities? And how do you find them? I found, because I got involved with the branch, that I was able to seize every opportunity to expand my knowledge. Were it a conference, were it just an on-site meeting, or any get-together on the topic of ADR or arbitration, I was there. President Ann Robertson has already mentioned that within the mentorship scheme, there is a mentor loop pilot scheme that has begun by the Chartered Institute. That's going to be interesting to watch as it develops. And so I began in my sharing to realize that participation in the arbitration itself is important. Offer to even write the award or participate in writing the award. Offer to do research on a particular topic that is being brought about in your panel or your tribunal. Finally, network wherever possible. I used to take around a handful of little calling cards and offer them at every conference with my name, my address, and receive exchange of conference cards. That was helpful because I got referred to in a number of my arbitrations by persons from abroad. So a branch membership program and mentorship program will definitely enable you to see yourself as competent and fearless. I think one of the main issues that held me back initially was a little shyness. I'm not shy now, but shyness is definitely not the flavor of the day in arbitration at any event. You must step forward, step to the plate and begin. So by mentorship, you'll see that the battlefield is open and through mentors, your success is already stated. There are many mentorship opportunities, and they are as numerous as the number of senior persons, practitioners in your branch. And we have those in our Bahamas branch. at least 13, 14, and we're very privileged to have that. So right now, I'll close by saying I'm excited about the mentorship opportunities that can arise here in the Bahamas for our Bahamas CIArb branch. Thank you very much.
Thank you, Justice Nottage. And I must tell you, there could not have been a better person to speak to mentorship opportunities. I know a number of members of the branch are grateful to Justice Ruby Nottage for having been a mentor. Thank you. And let me see if our attendees have been listening to that presentation, to President, and to all the presentations that we've had so far that speak about networking. Put yourself out there. And so let me test you. Let me see that email address in the box. If you would like to be reached, if you want to put yourself out there, if you want to say that you were at the first international webinar for the CIArb branch of the Bahamas, for the Bahamas branch, put that email address in the chat. You never know what great things may happen. Our next panelist is Dr. Peter Maynard, who will address us on his reflections on the road to ADR and a center post-pandemic. Dr. Maynard is the senior partner of Peter Maynard Counsel and Attorneys. He's a fellow and a former chair of the Bahamas branch of the Chartered Institute of Arbitrators. Please welcome Dr. Peter Maynard while you put your email addresses in that chat. Dr. Maynard.
Thank you, Carla. Good evening, everybody. As a sole male speaker, I am the thorn among the roses. But I thoroughly enjoy the pearls of wisdom and the progress the branch is making in this first international webinar. And it is great to see you again and to enjoy your amazing practical insights. I wish you every success during the rest of your tenure. I commend and thank for the invitation, Chair Rangan Johnson, Doneth Reed Cartwright, Carla Stubbs, and a shout out to Yolande. I like the references to Malcolm X and Kofi Annan in your vote of thanks. And also to Nicolette Gardner, who is doing a terrific job as the treasurer. I am always pleased to share the vision of these strategic CIArb meetings as we look past the current challenges posed by the global COVID-19 pandemic to a near future when we can have some of our meetings face-to-face or in a hybrid form. It is of paramount importance that dispute resolution professionals continue to educate themselves and be receptive to change. In addressing the inaugural session of the International Mediation Summer School 2021, the Chief Justice of India, N.V. Ramana, encouraged law students to learn the skills of mediation and ADR in dispute resolution. He said, "Justice does not always require black gowns and elaborate arguments. The future belongs to mediation and other forms of ADR." I want to share two primary reflections. One, institution building is so important for national development, and CIArb plays an important role. Two, it is also important for those institutions to work closely together. Arbitration, adjudication, mediation, conciliation, and negotiation have a long history here, but I would like to think the pace quickened at the turn of the new millennium, and we have achieved at least 6 milestones. Firstly, a mediation clinic, ADR development took a giant step in 1997 when when ADR indeed was projected as a disruption millennium issue. As part of the action plan of the Bar Association, of which I was privileged to then be president, and of also the Caribbean Organization of Commonwealth Caribbean Bar Associations, it was important for lawyers and other professionals to unlearn old behavior and to train for a new era of more efficient dispute avoidance, management, and resolution. Therefore, in addition to the major Bahamas Bar Association and ARCBA conferences, a 6-month pilot mediation clinic was established in about 1997. Secondly, the Bahamas joined the New York Convention, and I hope the Bahamas will join the Singapore Convention so that mediation settlements can be enforced in addition to arbitration awards. Thirdly, the Arbitration Act of 2009, which was promoted by the maritime sector in particular, and is currently being supplemented by an international commercial arbitration act. Fourthly, the establishment of the CIArb Bahamas branch as a vital institution for training and certification. Fifthly, the 10th anniversary of the Arbitration and Investment Summit, Caribbean, Latin America, and other emerging markets, will take place on Friday, the 28th of January of next year. The first summit was in 2012. I hope indeed Anne will join us, and also that John Bassey will join us, as well as the entire CIArb executive and membership. And CIArb has consistently supported it as it has gone from strength to strength. The summit has played a pivotal role in increasing awareness and promoting the use of ADR throughout the region. I look forward to our continued collaboration. And finally, and sixthly, IWAM, in about 3 years ago, the impetus began to establish an international and Western Hemisphere arbitration, adjudication, and mediation center, IWAM. It has been formed as a pro bono and nonprofit company. The center initially was located at the University of the Bahamas, which would conveniently be of great benefit and provide exposure for the students as well and faculty to become engaged. UB is training the next generation of ADR professionals in its clinic, and will, as suggested indeed in the remarks of Anne, will be applying for its courses to be approved by CIArb. The intention is to benefit not only UB, but also the economy and society. IWAM is establishing ADR centers in Nassau and Freeport. The IWAM centers serve both domestic and international purposes. During and post-pandemic, IWAM is suited to the use of technology to accommodate hearings on Zoom and other platforms in cooperation with UB, CIArb, and otherwise. I note in Anne's remarks that CIArb that does not administer arbitrations, and only in limited circumstances acts as an appointing authority. I acknowledge and emphasize that CIArb is the global leading institution for education, training, and certification in dispute resolution, and will be an important source of technical assistance for IWAM centers. I would like to assure you that IWAM can be greatly assisted by the expertise of CIArb by taking advantage of CIArb's continuous professional development programs and short courses on negotiations, expert witnesses, tribunal secretaries, workplace mediation, and other courses referred to by Anne and my fellow panelists to further develop our capabilities. So I return to my primary reflections. One, institution building is so important for national development, and CIArb plays a key role. Secondly, it is also so important for these institutions to work closely together. Thank you for allowing me to say a few words about our relationship. Thank you so much.
Thank you, Dr. Maynard, our sole male speaker and male representative. You held the side well, Dr. Maynard, and lest anybody think we're involved in gender disparity, I'm going to ask everybody to look at our page where you will be able to see the members of this distinguished branch. And that page has been put in the chat for you. So visit us at www.ciarb.org or Network Americas Bahamas. Please look in the chat.
It's to be encouraged.
And yes, Dr. Maynard is inviting more men, but we do have distinguished members, including many men in our branch. But please go to our branch if you want more information in relation to the branch and contact information as well. And I want to thank those who put their emails there. Look to see how you can have a network, and I'm sure the branch personnel will take note of it as well. The next person on our panel who will speak, who you will hear from, is Carol Lashley, an attorney at law. She is currently chairperson of the ADR Committee of the Bahamas Bar Association and has been a fellow of the Chartered Institute of Arbitrators since 2012. Mrs. Lashley will address us on the status of the Bahamian legislation. Please welcome Mrs. Lashley, Carol Lashley.
Thank you. I am especially pleased to speak to the status of Bahamian legislation, primarily because I participate on the legislative team with many entities. The Bahamas branch of CIArb, of course, the Bahamas Bar Association, the Chamber of Commerce, and ADR Bahamas, all of which are very serious national stakeholders in this regard. CIArb Bahamas branch, however, is currently the standard bearer for ADR legislation in the Bahamas. We all know that there's no real necessity for legislation in situations where parties determine to utilize ADR as a dispute resolution mechanism. ADR is party-driven for the most part. And even where it is not fully party-driven, for example, in cases where parties inherit contracts with ADR clauses, parties still have the ability to play a part in the mechanics of the process. Over the past decade or so, the Bahamas has been very intentional in putting itself firmly on the ADR platform. With the 2009 Arbitration Act, the Trustee Act, as amended in 2011 relative to arbitration, and with the International Arbitration Bill, already presented to Parliament and hopefully to be made into law this year. We have tweaked the International Arbitration Bill to ensure that it is model law compliant. And we have ensured that our drafting relative to the domestic legislation is equally current and compliant relative to the global gold standard. We have also finalized our draft on mediation. We have followed the model law. Although we have not signed the Singapore Convention, our draft legislation on mediation is model law compliant. We have ready, as soon as the arbitration bill is passed, the bill relating to international commercial mediation and international settlement agreements resulting from mediation. This bill is ready to go. Likewise, we have drafted the bill relative to domestic mediation and mediation settlement agreements. We have also, relative to these bills on arbitration and mediation, completed the drafting of some regulations, because we're of the view that the regulations relative to these pieces of legislation will be very similar. While there are many other topics, for example, trusts, maritime and aviation, environment, oil and gas, sports, elder care, family, employment law, insurance, including medical malpractice, real estate, cybersecurity, intellectual property and artificial intelligence, and restorative justice that we have identified and put on our legislative agenda. The only other area in which we have undertaken serious work is construction adjudication. Construction adjudication is a very important area for immediate attention in our jurisdiction. And very many segments of our community identify with this form of ADR. We have been speaking with various stakeholders, and there's concern on the part of the contractor architect group, as well as on the part of the property owner group. Construction adjudication, however, to be effective requires legislation. Strict timelines and definitions of who can be parties or matters which can be submitted to adjudication are all very important concerns. During the course of our drafting, we have reviewed somewhat in detail the law in Canada as well as the law in Ireland. While we have looked at other jurisdictions to date, we have only done so cursorily. The reality is that we are fairly satisfied that the experience and the testing of the legislation in Canada and Ireland will stand us in good stead. Also, the similarities of our jurisdictions make us comfortable in relying on their knowledge and expertise. While I can elaborate a lot more, I think I should stop here because I've only been asked to give a very brief overview of our legislative position. And so I thank you for your attention.
Thank you, Carol. And I'm looking at the comments, inspiring presentations. And as a reminder, if you want to know a little bit more about our panelists, please go to the event page where you registered, CIArb.org. When I told you we have a deep and wide bench in the Bahamas, I was not joking. And if you've been following, remember President Anne spoke about the importance of the post-nominals. You know, it shows high expertise and ethics. How many of our 5 presenters so far have you recognized is a fellow? How many? Let me give you a hint. We're going 6 for 6. And the next panelist is also a fellow, 6 for 6. This is the Bahamas branch. Kelvin Cunningham, barrister and attorney at law, is a senior partner in the law firm of Kelvin Cunningham and Company and is the chief executive officer of the Alternative Dispute Resolution Center. She too holds the designation fellow. Kelvin tonight will address us on ADR and the pandemic. Ms. Cunningham.
Good evening, and thank you very much. I adopt the protocol that has already been established by President Anne and Chairman Rangan. Tonight I'm going to talk to you on the CIArb in the pandemic, ADR in the pandemic. The coronavirus, COVID-19 pandemic has presented judicial systems around the world with unprecedented challenges, with many courts being forced to close or left trying to deliver access to justice in a safe environment. Some jurisdiction deems the courts to be an essential services, and they must continue to operate. And the courts must be open even when they are conducted online. Court systems around the world try to adjust, first, in some instances, by closing down completely, particularly in the first wave of the pandemic, and later, when they got their footing, so to speak, started telephone or video conferencing, and then online hearings. However, this the court sort of being blindsided by the pandemic resulted in a huge backlog of cases in most of the court systems. It is understood that in the UK, the backlog of outstanding cases increased by almost 200,000 since the start of COVID-19. Now, this increase is despite of the Ministry of Justice having invested millions in setting up Nightingale courts, which are temporary courts set up in order to tackle the huge backlog of cases. In our jurisdiction, we know we do have a backlog, and in recent times, a number of new justices were appointed, and the courts now are conducting mostly online hearings, seldom in person. Now, the impact of the pandemic seemed to have been greater on the court system, on litigation proceedings, than ADR proceedings in general. ADR proceedings were not affected as badly as litigation, as badly as the court. I read an article recently entitled Arbitration and ADR, thriving in a time of uncertainty. And indeed, alternative dispute resolution, ADR, is thriving even in the pandemic. One of the reasons for this is that for those who are familiar with the practice of international arbitration, the pandemic has merely accelerated certain trends that had already been begun before the pandemic hit us. In particular, the usage of technology has long been deemed necessary to facilitate the arbitral process. From as early as 2007, the International Chamber of Commerce had already provided for techniques incorporating technology to be used to safeguard parties' interest of time and cost. Now, time does not permit me to go into more detail because I've only got 5 minutes. But ADR has indeed thrived during the pandemic. And I want to say for the record, the ICC recently announced that it recorded a record number of 949 new arbitrations in 2020, as parties have embraced the use of remote hearings in arbitration. Regional arbitration centers likewise has thrived, and they saw a record number of cases filed in 2020. For example, Singapore International Arbitration Center reached 1,005 new cases filed in 2020. This was at the height of the pandemic. And this doubles the number of recorded cases in Singapore in recent years. And even with this ongoing pandemic, Singapore opened its 5th international office in New York at the end of this year. Or I should say at the end of last year, which was 2020. The commercial mediation market grew by 38% in the 12 months leading up to March 2020, the start of the pandemic, with approximately 16,500 commercial mediations performed in the UK, according to a biannual audit by the Centre for Effective Dispute Resolution, CIArb. Ladies, I have a lot more to say, but I think my 5 minutes is up. I should say participants, I have a lot more to say, but my 5 minutes is up, and I thank you for the opportunity to present. Thank you.
Thank you, Kelvin. I know we're inspired. I'm seeing the comments in the chat, and at this point, I'm seeing the time, but at this point, we still do have a few minutes for questions. If anybody wants to ask a question, please put it in the chat. But you also want to look in the chat because there's some really interesting information. I see the networking is going on already. 2 things I want to bring to your attention. If you do want more of this fantastic information and to get resources, the Bahamas branch has published its newsletter, The Adjudicator. And if you would like a copy of The Adjudicator, please email us at CIArb Bahamas etc@gmail.com. The address is in the chat. And you also have we have an invitation. We're privileged to have an invitation to join a private LinkedIn group. I tell you, when you come onto an event facilitated by this branch, great things happen. I don't see any questions, so I am going to go to questions. We can probably take 2 or 3 questions that we received beforehand, and I know that persons are looking forward to the answers. So the first question that comes up is, and I'm going to field it, it's to the last panelist, Kelvin, if you don't mind, is with the success of remote court litigation and with the success of remote ADR, do you think that the court would perhaps cease in-person hearings for litigation? Heavy question. I don't know if you can give us a truncated answer.
I do not think so. The benefit of court litigation is to have that interpersonal relationship when you see how an attorney, it's a mentoring session. As you sit in a litigation, you have an opportunity to see that interpersonal relationship and the body language and the way senior counsel, we're talking about mentoring, and that is mentoring. When you see senior counsel in a litigation, you see how to conduct yourself. For junior counsel who may not be familiar, you see how to conduct yourself. You see the respect given. You see the way that you address the bench. You see the way you present your arguments. So it's almost as if you are sitting in an articleship. So I do not think that would disappear. I do not think so at all. I think once things settle, we will get back to normal. Now, I do feel that we will continue to have telephone hearings, conferences, and electronic hearings. That will continue, but not in every case.
Thank you, Kelvin. And I do see that we have President Anne still with us. And so I will go to a question that's been posed to her. it's a little bit different from what we've been speaking about. And so the question is there a CIArb program, CIArb program, designed to train newly elected officers and an executive team? Is there a CIArb program designed to train newly elected officers and an executive team?
If you're talking about newly officers to the Chartered Institute and the branches, is that the question?
I'm sorry, it appears to be for the branches from the context of the question.
Yes. Yes, there are efforts to put something like that underway, and also the regional branch meetings with the chairs of the various branches are also a way to impart information to them as to what is occurring and how they may capitalize on that. And that is something new that's only been around for about a year, so that people can become familiarized. I mean, when I became chair of the North America branch, it was just like, well, here you are. And I felt like Alice that had been dropped down the rabbit hole. And someone came over to talk to me about all these programs and things and training they did that we didn't do in North America, and bylaws that no one had ever seen and so forth. So I'm hopeful that all those things are being addressed. And I know that one of Catherine's goals is to make this where it's seamless for all the members.
Thank you. And just a reminder, we have time for 2 more questions. So if you have a question, attendees, this is the time for you to drop that in the Q&A box. In the meantime, I do have a question posed to our panelist, Cherise Cox-Nottage. Would you say that in your view, the Bahamas is supportive of arbitration?
Oh, very much so. I think Mrs. Lashley, Carol Lashley, did a very excellent job outlining the state of readiness of our basically ADR legislation. So no, I think without question. We also, of course, in addition to having the legislation and that underlying support, we do, of course, very much have the support of the Chief Justice and very much the ministers of government whose portfolio would cover ADR. So I think on all levels, we're very much ready, and it's just a question of, I think, getting the message out that we are ready, willing, and able.
Thank you for that. And we do have a question for Dr. Maynard. Given the unpredicted nature of the pandemic, is the branch preparing to host hybrid hearings? Given the unpredicted nature of the pandemic, is the branch preparing to host hybrid hearings? Dr. Maynard, you want to take that?
Yeah. Well, as indicated by Anne, CIArb doesn't hold hearings. And that's the value of the close relationship with other institutions, such as centers, and indeed those which are developing in our context. And so presently, CIArb has been very supportive of other institutions such as there is the UB ADR clinic, and of course I mentioned IWAM as well, and so those venues are available, and they have facilities to have hearings electronically, and indeed when in-person hearings come into play, they also have facilities ranging from very modest facilities to bespoke facilities. In other words, the Franklin Wilson Center is used as a place for arbitrations at the university, for example. And of course, we have all kinds of venues available. And of course, there's a very strong complement of electronic platforms which are available as well.
Thank you, Dr. Maynard. And the very last question. So, we have the last question and then we have the very last question. And this last question goes to President Anne, perhaps a good question on which to end. I know, President Anne, you addressed this in your presentation, so it's perhaps a good place to end. Would you say that virtual training and assessment protocol of CIArb are here to stay?
Well, certainly I cannot make the final decision, but I would say that yes, indeed, it is here to stay. And there are many reasons that drive that. One is the ease at which it is to put on programs. Two is that it is much more economical to put on those programs. And three, you can reach a wider audience. And four, because you have reached a wider audience, you have greater geographical diversity in those particular training programs, which only serves to strengthen those programs.
Thank you so much. And seeing no further questions, we have an interesting part of this poll that requires some interaction, and I'm going to invite, is it Donna Cartwright, to launch the online poll. And it has been launched. We would invite our attendees to take our quick poll to evaluate the sessions today. Now, we know you said it was inspiring, informative. If you're not already a member of a branch, you want to be a member of this branch, or you want to create some relationship with this branch, please take a moment to evaluate today's session. And while I give you that moment, just 3 questions. I do remind you that you can find us online. If you want a copy of our newsletter, please let us know by email. All that information is in the chat. So please take the time to look at our 3 questions today. Did you find the content of today's meeting useful and interesting? Was the meeting structured and well organized? Was there adequate time provided for questions and discussions? I'm going to answer that no. We need a lot of time to discuss this interesting thing, but we did in the context of this. And I assure you, you see this branch evolving. We will be having more events, and we invite you to contact us, communicate with us, let us know what you would like to hear from us. Donna, have you received your responses?
Yes, they have been coming in. Not everyone has completed. So I think they're probably still working on it.
So what I'll do is ask our attendees to work on the poll. And in the interest of time, would you like me to move on to the vote of thanks?
Yes, please.
I invite the first vice chair and the honorary secretary, Shalling Ingram, to bring us the vote of thanks. Shalling. We can hear you. We're not seeing you, but if you'd like to go ahead, please bring us the vote of thanks.
I'm trying to get in.
There
we are. Yes. Okay. This is what I want to do. Okay. A writer once said, try not to become a man of success, but rather become a man of value. And that's by Albert Einstein. And today, I see the value in all of the presentations here today. A pleasant good day to everyone. We at CIArb Bahamas are truly grateful for your participation in today's webinar. And I would be remiss if I did not mention our guest speaker, even though she was previously acknowledged by Yulan Roll. we thank her for her presentation to us on CIArb and ADR courses. And we are truly grateful for the informed and enlightening topic and the way forward in arbitration. And not only that, she also took us back to the history of arbitration and led us to where we are today. And for that, we are truly grateful. And we do hope that for your continued support at the Bahamas branch, and we look forward to future engagements like this, and hopefully in the not too distant future. We thank you again. We would also like to thank our moderator, Carla Card-Stubbs, for directing our panelists today and keeping them intact with the flow of thought-provoking questions and ideas for today's agenda. And for that, Carla, we are truly grateful and thankful for your participation and leading the moderating today. We thank the panelists for their inspiring and informative presentation today as well. We thank Rengin Johnson, our newest chair for CIArb Bahamas branch, and her topic of vision for the Bahamas. And we thank her for sharing those opportunities for us and the way forward in ADR. We thank our former chair, Cherise Cox-Nottage, and of the Bahamas branch on applications for ADR and walking us through the process of the dispute of ADR itself. We also thank Carol Lashley, who is our legislation chair for the branch, and her topic on the status of Bahamian legislation. And we thank her for keeping us up to date on our legal position in ADR. And we thank Dr. Peter Maynard for his presentation today and bringing us up to date on his vision in CIArb and the success of his international summit and the success of the establishment of IWAM, as well as his success with the university students at the University of the Bahamas. We thank him for that. We thank retired Justice Ruby Nottage, who has a broad history. We thank her for her topic on mentorship and opportunities, and I thought that was very timely. And this, in helping us to be guided by the many steps available in ADR. And she also brought her personal experience into it. And so I thought that was very helpful to each of us moving forward and in ADR, giving us some ideas. And we thank Kelvin Cunningham, the first fellow of the Bahamas, and speaking on the topic ADR and the pandemic, and that is very timely. We are very pleased to inform, and of course you would have all been informed in any event, that all of our panelists are fellows. Some are our newest fellows in the Bahamas. And we would also like to thank, of course, the organizers of the event and our host for the event, Doneth Cartwright, for her continued and stunning work in public relations. And for that, we are very grateful. Thank you for that. We also are pleased to say that we finally, we would like to thank all of those persons working behind the scene again, and our esteemed virtual audience for helping to make this event a resounding success. I would like to close by saying, and this is by Nelson Mandela, who said, "A winner is a dreamer who never gives up." And that is exactly what we strive for in the Bahamas, and all that we should be striving for. I will end now. Thank you again, Madam Organizer, Doneth Cartwright, and the floor is now back to you. Thank you.
Thank you, Shellen. And so with that, we would like to say Good night, good evening, good morning, good afternoon, wherever you are. We're so grateful that you chose to spend your time with us. We know that you were informed, many of you were inspired. If you do wish to reach out to us, please do. And for those who are bold enough to put their email addresses in the group, we will reach out to you. Have a wonderful evening, a wonderful afternoon, wherever you are. Thank you.
Thank you.